I'll hang out, maybe ask a few questions or something like that. But why don't you just start with at each of you, like your description of your jury experience, and maybe we'll get more detail in a second. Chuck, you ready?
Okay, I'm ready. Start?
Please.
Okay, full disclosure, when I was on this jury, I was a prosecutor. In fact, I was the chief of the misdemeanor division, and it was a county court case that Natalie Tice was prosecuting. I'm sitting there in the jury panel thinking, I'm out of here pretty quick. And bam, they called my name and I was on the panel. Natalie Tice fainted because I was her supervisor at the time. But I ended up on a jury involved in County Court 3 with Gerald Pate sitting as a visiting judge. Allegation was that the defendant had been showing his tallywagger around the apartment complex where he lived. It was kind of an interesting experience. The whole panel that I was with knew that I was a prosecutor because in the voir dire process, I was identified by everybody as being the prosecutor's boss and all this. So it was kind of a weird dynamic. When we got back in the jury room, I figured I better keep my mouth shut and just not say anything and listen to what they had to do. A couple of things that I learned in that trial. Number one, the minute an extraneous offense come in, your client is dead. You know, this panel, the defense in the case was a little bit bizarre, and he probably was already convicted when his girlfriend got up and testified that they had gotten engaged that day and that they had had wild sex all night long, and that he would have been incapable of having an erection to show out the window to the girl that was walking on the sidewalk. And, you know, that pretty much was like, oh, really? You know, boom. But once that came in, and then they brought in the other little girl that said he was in the laundry room dropping his drawers, it was like, bam, he was dead. And it was really surprising how strong extraneous evidence. I'm sitting there thinking, well, surely this jury is going to, you know, they're going to consider everything. But man, when that second girl came in, they were just, he was guilty on the spot. So it was kind of.
How did you find yourself deliberating? Like, what was in your head? And you know what's going on. Did you make an effort to kind of be withdrawn, or?
Yeah, I really did. I made a big effort to be the quiet, silent member of the panel because I thought, this is just ridiculous. Why am I on this panel? This is crazy. I got on the panel because apparently the attorney for the defendant did not know how many strikes he had in misdemeanor court. And Judge Pate, during the eliminating striking portion of the trial, was giving a lecture to us, the jurors, explaining to us how strikes work and blah, 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 blah. So when I get, my name is called, I'm looking at Judge Pate, and he's looking at me, and I'm going, there could be a mistake here, Your Honor. You might want to check that. And he looked, and he said, you know, since I'm sitting up here giving a speech about how to make your strikes, and you made your strike, you're stuck with Chuck Noll. So I ended up on the panel. And I figured, you know, this is, in all fairness, I better just not say anything. And they wanted me to be the foreman. I said, nope, not going to be the foreman. Let somebody else be the foreman. Kept my mouth shut. At the end of the trial, I was the guy with, you know, they wanted everybody to write down what we thought would be a fair punishment. And I put mine down, and mine was the low ball. So I figured, okay.
So it was a punishment to the jury as well?
Yeah.
How did that roll out with the jurors starting to talk about it, remember, in terms of how it's approached?
Well, you know, it was amazingly enough, they were like, and another thing I picked up from being on this panel is how quickly the herd instinct kicks in. You know, they bonded like almost immediately back there, and as soon as they decided he was guilty, man, it was like, we're going to teach this guy. You know, it was really a gang up kind of thing. There was no dissent. Everybody was slam bam, thank you, ma'am. I saw how fast that happened. I was the only one that didn't want to max the guy out. I mean, they were ready to go, and you know, once that herd mentality starts, boy, it was like a railroad train back there. I have to hand it to anybody when you get these 11-1 verdicts and you've got somebody back there hanging in there. Boy, that's got to be a tough dude, because they were poof. In their deliberating, it was like no nonsense. We don't want to hear anything. Okay, write down what the proper punishment is, you know, that kind of thing.
So was it a range, or like most people were like maxed
Oh, they maxed out. Everybody had 6 months, and the fine, and I had just 6 months. You know, I said, why do you want to fine this guy? No, they did the fine. I said, whatever y'all want, I'm out of here. I capitulated real quick.
Pat, you ready?
Sure. I took notes because I didn't remember anything about this, although it happened a year and a half ago. I was juror number 6 on the state of Texas versus James Bishop in Kristen Guinea's court. Carol Burton was the prosecutor. Rick Gonzalez was the defense. It was a murder case. Mr. Bishop was dating a 16-year-old girl, and mom found out about it. He was 32. And mom found out about it. He looked young, and so mom was okay initially, but then she found out he's 31 or 32 years of age. And mom confronted him and said, look, stop seeing my daughter, I'm going to call the cops on you. The state's evidence would show then that the daughter and Mr. Bishop plotted to kill her. They first tried to poison her. She went to the ER, said she had been poisoned, but they had no real idea as to how, so she came home, told a neighbor across the street, I think that they're trying to kill me. A month later, that neighbor looks out the window and sees Mr. Bishop in the evening squatting in the front yard and sees him go behind the house. The neighbor and the victim, the mom, were friends and had coffee every morning, and so when she didn't show up and have coffee, they went and knocked on the door, and the mom was found on the couch in the living room, and she'd been stabbed 20-something times while she slept. Mr. Bishop ultimately was arrested, provided 3 statements, all of which were inconsistent and offered into evidence. First one said I didn't have anything to do with it. The second one was that someone named Ray Ray in the county jail told me he did it, and Mr. Bishop then told the police a detailed step-by-step version of exactly what Ray Ray had said to him, which eerily matched everything at the scene. The guy still didn't get charged until about 2 years later when someone from a TDC unit, the jailhouse snitch, contacted I think his lawyer, and the lawyer contacted the head homicide sergeant. And so the homicide sergeant went up and visited with this guy, and the guy basically said, yeah, he told me this. Let me tell you what he said. I was in county 2 years ago when this happened. I've been down here for a while. You know, this kind of conduct, even in prison, goes beyond what the code ought to be, and so I'm offering up my services. I don't want anything in exchange. He did a blow-by-blow that also exactly matched what went down. Mr. Bishop did not put any evidence on. Rick did a great job. He was convicted quickly. And punishment, he came and testified and looked at us and said, Ray Ray said this, and went by and basically did the entire murder scene for 15, 20 minutes. And it was exactly, like looking in the eyes of someone who is confessing to you, except for Ray Ray told me this. And then he would go in and say everything. And they offered up his 2 trips to the pen, both for indecency of a child by contact, and it's a 25 to life. And same as you, they knew I was a prosecutor and a longtime defense lawyer, and so I bowed out of doing anything. And I asked them if I could speak last as we went around, and they said that's a fine idea. And he received life, and unfortunately took his own life the next day in the county. So it was kind of a crazy one. If you believed he was guilty, well, other things that we did not know really did indicate he was guilty. For example, the daughter had flipped and offered the plea to a cap of 20 in exchange for testimony that the state chose not to offer. Stuff like that. It was emotional for both me and everybody there on the jury because it was crazy. I've been down here 25 years. One of the more crazy cases I've ever seen, and I've seen a lot of crazy stuff. In terms of my experience, these people, when they're on the jury, notice everything. And remember that when they go back there, They can't talk about the evidence. And we were in trial for a week without anybody talking about evidence. And so they got to talk about something. And so they, you meet them, you get to find out who they are, what they do for a living, family, stuff like that. And that's over in about a day. And so then they start talking about not evidence, and they tried a couple times and I shut them down, but they start talking about, did you see that in there? First thing they noticed was, and I'll never forget this because I'd never noticed it, and many of you have, I'm sure. As you look into a courtroom, all of where defendants rest their head, and that stuff. First thing they noticed. Everybody noticed. I was like, are you kidding me? And I looked and I saw it. Beth Exley was the prosecutor and was trying at the time to beat her smoking habit, and so she was chewing gum, and the older jurors would have none of that. I mean, how rude of her to be chewing gum during evidence. And I was kind of like, I better keep my mouth shut. But they were angry about that, the older people. I mean, that showed no decorum to them. Kristen Guinea was, why does a judge keep surfing the internet during important testimony? That really bothers me. And I knew she was, in real time reading the testimony, but, let them think what they want to think. And, you always got to be careful about, and Leitner told me this when I got out 17 years ago. Always know, what I've learned again from this experience, always know your forum. And your forum is always the jury when you're in a jury trial. You can know your forum and what someone's going to do in punishment if you plead without an agreed rec, but always remember what your audience is and what they hypothetically could be thinking, and what they're thinking is everything, at least in my experience. These people took it very seriously. Back when I was a DA years ago, the mentality was, if you got a guilty, it's because the defendant was a bad guy, or you did a good job, so you thought in trial. But you never really gave the jury credit for seeing things the right way. It was always you or the defendant. And if the jury came back not guilty and you were the prosecutor, you always blamed the jury. Like, those guys are, I lost that case when that jury panel walked in the door. That's nonsense. And I knew that when I got out and started becoming a defense attorney. And what I learned and what was reaffirmed for me is these guys take it real seriously. And I can't speak for DWI cases, but this kind of stuff they take real seriously. If someone is really looking very guilty and they know up front that the guy's going to get a lot of time if they find him guilty, they want to know everything. And so that's one of the things I found the most important. But during the trial, you got 12 pairs of eyes that are looking at you and looking at everything as you're the attorney and the lawyer. One guy came back and said, hey, that visiting bailiff, did you see him? I was like, no. He's like, man, that guy can't quit scratching his balls. And 3 other people said, I saw that. That's so offensive. I was like, holy smokes. I remember hearing a story years ago about Johnny Sutton, who some of y'all know. And he was just in a horrible trial in front of Ted Poe. And he would put on evidence that was just horrible and great state's evidence. But the jury could not, so the story goes, quit looking at Max Seacrest, who was the defense lawyer. And every time something went bad, he'd be doing this, and they'd all be looking at him while he's cleaning his glasses. And so they're watching everything. Pissed Sutton off because they were missing the point, so he thought. But they're always watching you. They want to identify with one. This is what I learned. They're critical of people that are putting on the case and sympathetic as well. They were very sympathetic for the defense because they saw what they saw. He had very little to work with, and as a result, they were naturally more critical of the prosecution. And they want to identify with someone. They really didn't do it openly in this case, but I could tell that they wanted to. That's the first thing. So always remember, as Leitner said, your forum. I'll never forget that now that I've had this experience. The second thing is you never know until you get to the deliberations what people are thinking, and then it's like, wow, really? And the more serious the case, the more I've now changed my philosophy. I've always had a pad and paper next to me to take down ideas from for closing arguments when that's happening, as it happens in real time. And What I'm going to do now is I'm going to have a pad there for, as it happens, everything the prosecutor is missing. You'll think about something when they put on evidence and recognize most of the time these young guys are offering up stuff and, okay, who's my next witness, and they're not thinking big picture. But when they miss stuff, write it down, because the first thing these people start talking about in the back is, well, why didn't they put on any DNA evidence? Well, I knew why, but that really upsets people. And when they don't get to hear what they want out of the prosecution, they get mad at them. And when they're told in a jury charge, consider the evidence, it's all before you, they get even more mad. And I've never really thought about that until this time. And so the more difficult, when my case is good, I always wanted to appear to be the reasonable guy as a criminal defense lawyer and watch the prosecution struggle, because I believe the jury was looking at that and saying, hey, he's really cool about this, and he's not being nasty or mean, and he's staying above the fray, and look at the prosecutor struggle. But as the nastier your case becomes, there's going to be somebody back there who can identify with your pad of paper and, well, where was the DNA evidence? Where is, they're talking about this Ray Ray guy. Well, where's Ray Ray? They had a list of about 10 things. And that's what I got the most out of this, is once you are, and you got to figure out how you're going to do it. You don't want to have the prosecutor have the opportunity to rebut it. But, and on serious cases, I would now personally do it in closing and say stuff like, look, the prosecutor had the opportunity to bring in DNA evidence. Here's why it's relevant. It's their burden. They're going to stand up after me in closing argument and give you an explanation as to why. But what that really means is they didn't think it was important to you.